The subcommittee will come to order. Today, the subcommittee is holding a legislative hearing on two bills, H.R. 2221, the Data Accountability and Trust Act, and H.R. 1319, the Informed P2P User Act. The chair will recognize himself for 5 minutes for the purposes of an opening statement. Today, the subcommittee is holding a legislative hearing on the two above-mentioned bills. They were both introduced by two distinguished members of the subcommittee, my colleagues, Mrs. Bono Mack and Mr. Barrow. And H.R. 2221, which is the Data Accountability and Trust Act, also known as DATA, was introduced by myself and Mr. Stearns. Ms. Bono Mack and Mr. Barrow introduced H.R. 1319. Both of these bills represent strong bipartisan efforts to address high-profile problems affecting American consumers. H.R. 1319, the Informed P2P User Act, addresses the increasingly frequent problem of consumers inadvertently exposing their private, sensitive information by way of peer-to-peer file sharing programs. Too often, when consumers download these programs onto their computers with the intent of sharing and downloading certain files on the network, they are unaware that they are also sharing other files they otherwise might want to keep private. For instance, recent media reports have focused on consumers unknowingly sharing their tax returns and their Social Security numbers on P2P networks. Such inadvertent file sharing can be the result of deceptive or misleading disclosures by P2P software companies, or they might emanate from simple confusion on the part of consumers. Whatever the case, the intent of H.R. 1319 is to provide consumers with the power of informed consent before they download P2P software onto their computers and share folders and files with network participants. The second bill that we will be discussing today is H.R. 2221, the Data Accountability and Trust Act. And this is the third Congress in which this bill has been introduced. Mr. Stearns, as chairman of the subcommittee in the 109th Congress, originally introduced the bill as H.R. 4127, and with the help of then-ranking member Schakowsky, it eventually passed the full Energy and Commerce Committee by a unanimous vote. However, no further action was taken on the bill as a result of jurisdictional disputes. In the subsequent 110th Congress, I reintroduced the bill as H.R. 958, but we were unable to take any action. Once again, in this current Congress, I have reintroduced the bill with Mr. Stearns, Mr. Martin, Ms. Schakowsky, and Mr. Radonovich as H.R. 2221 with the intent that it does eventually become law. H.R. 2221 has two basic components. First, the bill requires that persons possessing electronic data that contain personal information to take steps to ensure that the data is secure. Second, the bill establishes a notification procedure and process that a company must take when a data breach occurs in order to allow affected consumers to protect themselves. Companies do not have to initiate such notices if they determine that, quote, there is no reasonable risk of identity theft, fraud, or other unlawful act, end of quote. H.R. 2221 also imposes special requirements on data brokers but accommodates other laws that govern how certain data brokers are regulated. These bills may require some revision, and while this may not be the first time we're taking up data security, and H.R. 2021 already reflects significant changes forged by compromises made in the 109th Congress, the bill may be dated and in need of an update. This subcommittee is looking forward to working in a bipartisan fashion, seeking bipartisan cooperation based on our historical bipartisanship. And I expect that bipartisanship to be at work on both of these bills. And lastly, I want to just announce for the record that I have an intention to hold a joint hearing on consumer privacy with Chairman Boucher and the Subcommittee on Communications, Technology, and the Internet to work on comprehensive legislation. This is just a part of a larger process. With that, I yield back the balance of my time and recognize now for the purposes of an opening statement the ranking member on this subcommittee, Mr. Radonovich, for 5 minutes.
Thank you, Mr. Chairman. Good afternoon, everybody. I would first like to thank the witnesses before us today and the organizations that have offered comments and suggestions assisting the important work of crafting a robust and workable data security bill. Both that bill and the P2P bill that we have at their core concerns about the unauthorized or inadvertent sharing of sensitive information. I want to commend Mr. Stearns, Ms. Schakowsky, Mr. Barton, Mr. Dingell, Mr. Whitfield, and now Mr. Rush and Mr. Waxman, all of whom were chairmen and or ranking members who have helped bring attention to these issues. I also want to recognize Ms. Bono-Mac's leadership on digital security over the years and on her bill to prevent inadvertent file sharing on peer-to-peer networks. File sharing presents privacy and security issues, but also relates to online safety more generally. And being a father, I'm glad to see that a bill that improves children's digital safety and will help protect from some of the atrocities that are being committed using these networks online. Huge data security breaches shocked us all starting back in 2005 with the Choice Point breach, and millions of people in the United States had discovered that they are victims of identity theft. Billions are lost by consumers and by businesses as they spend money and time to repair their finances, particularly in difficult economic times when credit is increasingly tough to secure. The potential disruption and obstruction of commercial activity in every sector of the U.S. economy cannot be ignored. Internet-based and other electronic transactions are fundamental these days, and ensuring consumer confidence in these systems is essential. The Congress and this committee in particular are charged with the responsibility to ensure that the entities possessing and dealing in sensitive consumer data keep the doors locked and the alarm on. The health of our modern network system of commerce demands it. Very simply, H.R. 2221 would create a uniform national data breach notification regime. I believe that notification must be based on the actual risk of potential harm from identity theft or other malfeasance, and the mandates that we put on covered entities must be the same across the country. Allowing individual states to alter the rules will only lead to consumer confusion and unnecessary business expenses, costs that will inevitably be passed on to the consumer. Let's get a good bill that robustly protects consumers while not adding requirements that only add costs. The world has changed since we last considered this bill, and I'm anxious to hear about those developments. Some parts of the bill may now be obsolete given to the actions of the private sector, actions by both those who hold sensitive information and by companies who now offer products directly to consumers to monitor their credit. And we must take all of this into account and get a workable bill that we can all support. While the data security bill is one with which the committee has some experience, Ms. Bono-Mac's bill, H.R. 1319, is a relatively new one. She was out in front on the issue last Congress, introducing an earlier version of the bill last September. Since then, we have seen multiple news stories about the problems the bill attempts to address, inadvertent sharing of sensitive files across peer-to-peer networks. I want to state at the onset that it is not the committee's intent to simply demonize P2P software. There are many legitimate and important uses of this innovative program, and I'm glad that the P2P industry is here to talk about the uses of their products. However, the system The systems present some interesting problems as well. Last month, the P2P security company Tyversa, who was here to testify, found the schematics of Marine One, President Obama's new helicopter, on a P2P server in Iran. In other reporting, it was found that millions of sensitive personal records, including social security numbers, medical records, credit reports, and tax returns with names and addresses, were easily found on P2P networks. The problem of inadvertent sharing is enhanced by the actual architecture of the programs. It's often unclear to a user what may be leaked, and it can be difficult to change settings to prevent it. After Mr. Waxman examined this in the former committee down the hall, it appears that 2 years later, many P2P providers have not taken adequate steps to address this. We need to take a close look at the problem and the bill. We do not want to sweep technologies into a potential regime that we do not intend, nor do we want to exclude technologies that we can all agree should be covered. How we define P2P software is critical. Mr. Chairman, I look forward to the comments on these bills, and I'd like to express my gratitude to the majority for their intent to develop these bills. Thank you, Mr. Chairman.
The chair thanks the gentleman. The chair now recognizes Mr. Barrow for 2 minutes. Mr. Barrow is a sponsor of one of the bills, and we certainly are grateful to him for his legislative work. Mr. Barrow, you're recognized for 2 minutes for the purposes of opening statement.
Thank you, Mr. Chairman. We live in a world where digital technology has connected people and their ideas and their information and products, making possible all kinds of new kinds of collaboration and innovation. And there's no doubt that this has made us all a lot more productive. It's also made it possible for folks to invade our personal records and reveal private information about us and our families that we choose not to disclose. The purpose of today's hearing is to discuss threats to data security and ways we can work to fill in the gaps that leave our personal records vulnerable. I had the opportunity to work with Congresswoman Mary Bono Mack on H.R. 1319, the Informed Peer-to-Peer User Act, and I hope that this hearing will shed some light on the privacy and security risks that are associated with peer-to-peer file sharing programs. A lot of folks who connect to these networks don't even realize that their most personal and private files are visible to everyone else on the network at any time. A lot of folks are posting their tax returns, financial records, and personal messages on the internet and don't even know it. I hope that our work on this committee will come up with a strategy that will let individuals know in a way that they can understand and use that the information on their computers could be at risk. We have truth in lending, and we got truth in labeling. I think it's time we had truth in networking also. I want to thank Congresswoman Mary Bono Mack for allowing me to work with her on the Informed Peer-to-Peer User Act, and I want to thank Chairman Waxman and Ranking Member Barton for bringing these important issues to the forefront in our committee. And most importantly, I want to thank every one of you on this panel today for being here to lend your expertise on this important subject. Thank you, and I yield back the balance of my time.
The chair thanks the gentleman. The chair now recognizes the other author of this bill, one of the bills that we are hearing today, Ms. Bono Mack. Mr. Stearns, former ranking member of the subcommittee, Mr. Stearns of Florida, who's recognized for 2 minutes for the purposes of an opening statement.
Thank you, Mr. Chairman, and I think...
Excuse you with Ms. Bono Mack, but please
she's much better looking. Mr. Chairman, thank you very much, and I think in your opening statement you pretty much outlined my feeling about this. Obviously, this is a bill that was introduced on October 25th in 2005. It was H.R. 4127, and as you pointed out, we passed this bill by unanimous consent. Ms. Schakowsky and I worked together on that bill, and we had compromises. We got the bill. So I'm very pleased that you have taken the initiative, the leadership to offer this bill again, and I'm very glad to be original co-sponsor with you, and hoping that it has the same kind of success that we had, Ms. Schakowsky and I, because it's a very, very important bill. Recently, some hackers broke into a Virginia state website used by pharmacists to track prescription drug abuse. They took all these names, and it's 8 million patients, and they deleted them from the site, and they're asking for money to replace them. So in a way, they're asking for a ransom. And if this Virginia website had a encrypted a data security, a full-blown protection of this information. It would have been difficult, if not impossible, for these hackers to get in and to take this information. It's 8,257 million names. And that's why this bill is so important, so I'm very pleased to support it. And also, the gentlelady from California's bill, the Informed P2P User Act, which is, again, very important with the diverse connectivity we have in networks, and, of course, with the increased broadband that we're starting to see. People are going to go more to this peer-to-peer downloading, and this centralized resources in your computer, and these servers going back and forth between each other. You've got to have some notification to the users what's occurring, or a lot of their applications and their information will be also taken. So it's very appropriate these two bills come together, I think, Mr. Chairman. I commend you and your staff for bringing them both, because in a way we're talking about data security with both of them and protection of the consumer. And thank you, Mr. Chairman.
The chair thanks the gentleman. Now the chair recognizes Ms. Bono Mack of California for 2 minutes for the purposes of an opening statement.
I thank the chair and ranking member Radonovich and the distinguished panel for being here today. Thank you for holding a hearing on important privacy legislation. Today, my comments will focus entirely on H.R. 1319, the Informed P2P User Act. But before I dig into the issue of P2P, I would like to thank ranking member Barton, as well as my colleague, Congressman Barrow, for their willingness to work together on H.R. 1319. As you've seen, this is a bipartisan bill, and their support has been essential. I thank them both. The risk associated with peer-to-peer file sharing programs has been widely reported by the media and thoroughly investigated by Congress. Many of our witnesses today have testified before other congressional committees on the dangers associated with P2P file sharing programs. And each time, the committee was given a status update of the dangers. Additionally, industry claimed ignorance and stated they would handle the problem through self-regulation. This hands-off approach has not worked, and any set of voluntary best practices put forth by the P2P industry can no longer be seen as credible. To paraphrase Groucho Marx, he said, you want me to believe you and your voluntary measures instead of my own two eyes. How many more medical records and tax returns is it going to take for us to act? How many state secrets will be made available to those who want to harm us? How much more damage are we going to allow P2P file sharing programs to do to our economy? I believe enough is enough, and the time to act is now. Industry's opportunity to self-regulate has passed. P2P file sharing programs like LimeWire and Kazaa before it have proven they're either incapable of solving the problem of inadvertent file sharing on their own, or they have absolutely no intention of solving the problem at all. Either way, this behavior is unacceptable. And as a committee charged with consumer protection, we have a responsibility to our constituents to act. I'm also aware that some of you have concerns about some of the language of H.R. 1319. Please know that my office is very willing to listen to your concerns and work with you to craft a bill that is not overly broad, but still carries out the current intent of H.R. 1319. I believe that if we work together, we should be able to produce a bill that protects our constituents and preserves the legitimate use of P2P applications. I look forward to today's discussion, and I thank the chairman very much for holding this hearing. I yield back.
The chair thanks the gentlelady. Now the chair recognizes the gentleman from Pennsylvania, Dr. Murphy, for the purposes of opening statement. The gentleman is recognized for 2 minutes.
Thank you, Mr. Chairman. And by the way, I'd also like to welcome Pittsburgher, Mr. Buback of Tyversa. He and I have spoken a number of times in the past, as well as this incredibly distinguished panel, the expertise you all have. I'm excited about you being here. The sad thing about this is a discussion that has not begun today. I think some of you have testified in the past years, and I know that Mr. Buback and I have spoken years ago. When we look at what has been released about the documents from Marine One, a couple of terabytes of information on the Joint Strike Fighter jet, a whole host of so much more information, it makes me wonder why anybody trusts have any files on the computers at all. It reminds me of the way that Rome acted during the time the barbarians were beginning to invade various parts of Germany, and I'm sure some Roman emperor, some Roman generals were saying, nothing to worry about. We have this system under control, even when as they were sacking Rome. And I believe that's where we are now with the Internet. It is not safe. The portals created by these peer-to-peer networks are huge, and the fact that our Department of Defense keeps anything on any computer that is accessible from the outside still astounds me. I applaud this bill, and I think this is important because it does move a long way towards protecting consumers and families who inadvertently have their files stolen and accessed, whether it's their tax records, medical records, or anything else. But the best thing we need to remember for so many folks, whether they are John and Jane Doe in their home somewhere, or it is our Defense Department, or it is any corporation, that no matter what we do here, they are still responsible for keeping information inaccessible to the Internet. Because those folks from other countries who continue to send out press releases denying they're doing it, and yet all paths seem to lead back to those countries, we have to understand that the wealth of information we have on our computer networks and what we have done to protect those is all for naught if we continue to put those on computers. With that, Mr. Chairman, I yield back.
The chair thanks the gentleman. Now the gentleman from Nebraska, Mr. Terry, is recognized for 2 minutes.
Thank you, Mr. Chairman. I want to thank you for holding today's hearing, but most specifically, we've been down this road a couple times before, and I think it's imperative that we move these bills. This seems to be, I'm going to kind of pile on a little bit Mr. Murphy's comments that I view this as nibbling around the edges of cybersecurity. We're pointing to specific problems and trying to come up with specific solutions. All the while, we're losing sight of the forest. Not saying that these shouldn't be done, but I just think we need to think about it in a grander scheme of cybersecurity and how it all ties in with our national security now, our financial security. And hopefully we can start elevating the level of discussion here. But I want to congratulate the authors of both of the bills here. I think you've done a decent job here of finding a right solution for these specific problems, and I support them. Yield back.
The chair thanks the gentleman. Now the chair recognizes the gentleman from Georgia, Dr. Gingrey, for 2 minutes for the purposes of an opening statement.
Mr. Chairman, thank you for calling this hearing today that focuses on two bipartisan pieces of legislation, H.R. 2221, the Data Accountability and Trust Act, and H.R. 1319, the Informed Peer-to-Peer User Act. I also want to commend both you and Ranking Member Radonovich for your collective leadership and for the spirit of comedy in which the subcommittee is operating, Mr. Chairman. At a time when our society is becoming ever more reliant on technology, whether for e-commerce or HIT, health information technology, we need to ensure the security of an individual's identity and personal information. Unfortunately, we have seen significant breaches of information that have led to identity theft, fraud, and allegations that were first reported in the Wall Street Journal that Chinese hackers, is bad enough what Ranking Member Stearns was saying about the pharmaceutical and prescription drug information, but Chinese hackers stole several terabytes of data related to design and electronic systems of the Joint Strike Fighter. That's some serious business. H.R. 2221 is legislation that was first written in the 109th by my colleague from Florida, Mr. Stearns, and is now being spearheaded by you, Mr. Chairman. I applaud you on this effort. This legislation requires entities holding data that contains personal information to implement enhanced security measures to prevent future breaches. In the instances in which unauthorized access does occur, then the consumers must be notified shortly thereafter that their files were compromised. And similarly, H.R. 1319 is legislation that was introduced by Ms. Bono Mack of California, full committee ranking member Barton, and my colleague from Savannah, Georgia, Mr. Barrow, and it's designed to protect consumers through additional information about the practice of peer-to-peer file sharing over the Internet, simply referred to as P2P file sharing around the IT industry. This practice certainly has a number of benefits. However, Too often, personal information is compromised over the peer-to-peer programs for various reasons, many of which, of course, are inadvertent. H.R. 1319 would add an additional layer of security that would prohibit peer-to-peer programs from sharing files until the program receives informed consent from the user on 2 separate occasions. Mr. Chairman, we need to maintain security on the Internet in this growing technologically based world, and I do support both bipartisan bills. I look forward to hearing from the witnesses, and I yield back.
Indeed, the Chair thanks the gentleman, and the Chair thanks all the members of the subcommittee for their opening statement. It is now my pleasure to introduce our outstanding expert panel. These panelists have come from far and near to be with us today, and we certainly welcome them, and we certainly want to tell each and every one of you beforehand that we thank you so much for taking the time out from your busy schedule to participate with us in this hearing. I'd like to first of all introduce you now. From my left, my far left, is Ms. Eileen Harrington. Ms. Harrington is the acting director of the Bureau of Consumer Protection for the Federal Trade Commission. Next to Ms. Harrington is Mr. David M. Sohn, who's a senior policy counsel for the Center for Democracy and Technology. Next to Mr. Sohn is Mr. Robert W. Holliman II. Mr. Holliman is the president and CEO of Business Software Alliance. Seated next to him is Mr. Martin C. Lafferty. He was the Chief Executive Officer of the Distributed Computer Industry Association. I think I got that right. Next to Mr. Lafferty is Mr. Stuart K. Pratt, President and CEO of the Consumer Data Industry Association. And then followed next to him is Mr. Martin Rodenberg, I think I pronounced that right, who is the Executive Director of the Electronic Privacy Information Center. And the gentleman next to Mr. Rodenberg is Mr. Robert Bobak. He's the CEO of the Tyversa Incorporated. And lastly but not least, the gentleman that's seated next to Mr. Bobak is one Mr. Thomas D. Sittner. He's a senior fellow and director of the Center for the Study of Digital Property of the Progress and Freedom Foundation. Again, I want to thank each and every one of the witnesses for appearing today. It is my pleasure to extend to you 5 minutes for the purposes of opening statements. And we will begin with Mrs. Harrington. Mrs. Harrington, would you pull the mic close to you and hit the button to turn it on? Thank you so much.
Thank you very much. Chairman Rush, Ranking Member Radonovich, and members of the subcommittee, I'm Eileen Harrington, the Acting Director of the FTC's Bureau of Consumer Protection. I appreciate the opportunity to appear to present the Commission's testimony on data security and peer-to-peer file sharing. The Commission's views are set forth in its written testimony. My oral presentation and answers to your questions represent my views. Let me start with data security. Companies must protect consumers' sensitive data. If they don't, that data could fall into the wrong hands, resulting in fraud and consumers losing confidence in the marketplace. The Commission has undertaken substantial efforts described fully in its written testimony to promote data security. Let me highlight 3 particular efforts for you. Our law enforcement activities, our pending rulemaking on health information security, and our study of emerging technologies. Today, the Commission announced its 26th law enforcement action against a business that we allege failed to have reasonable procedures to protect consumers' personal information. Case number 26 is against mortgage broker James Nutter and Company for allegedly failing to implement basic computer security measures. In settling these charges, the company has agreed to maintain reasonable security measures in the future and to periodic outside audits of its security practices. The Commission's data security cases are well publicized and send a strong message to the business community. You must have reasonable data security measures in place. Second, a few weeks ago, the Commission issued a proposed rule to require that consumers be notified when the security of their health information is breached. The proposed rule arises from a mandate in the Recovery Act to address new types of web-based entities that collect or handle consumers' sensitive health information. Covered entities include those that offer personal health records, which consumers can use as an electronic, individually controlled repository for their medical information. Personal health records have the potential to provide numerous benefits for consumers, but only if they have confidence that the security of the health information they put in it will be maintained. Third, the Commission continues to examine new technologies to identify emerging privacy and data security issues. In February, for example, the Commission staff released a report recommending principles for industry self-regulation of privacy and data security in connection with behavioral advertising. We are also considering a petition submitted by Epic raising data security concerns about cloud computing services provided by Google. Finally, a few words about the proposed data security bill, H.R. 2221. The Commission strongly supports the goals of the legislation, which are to require companies to implement reasonable security procedures and provide security breach notification to consumers. We also strongly support the provisions that would give the Commission the authority to obtain civil penalties for violations. We have provided technical comments to committee staff, particularly with regard to the scope of the proposed legislation and the data broker provisions, and very much appreciate the opportunity to provide input. Turning to P2P file sharing, let's be clear about one thing. The FTC's interest is the safety and privacy of consumers' personal documents and information, not copyright piracy. Although P2P technologies may offer benefits to computing, they have also been associated with significant data security risks. The press has reported disturbing instances of sensitive documents being shared via P2P networks. Sensitive documents likely have been shared under three scenarios. First, some consumers may have shared documents because they failed to read or understand information about how to keep files from being shared or did not understand the consequences of altering default settings. Second, some consumers may have unknowingly downloaded malware that caused their files to be made available on P2P networks. Third, some businesses and other organizations that hold sensitive personal information, such as tax or medical records, have not implemented procedures to block installation of P2P file sharing software on their company or organization-owned computers and networks. Some of the most highly publicized instances of personal information being shared over P2P networks occurred because businesses failed to prevent the installation of P2P software on their systems, or because their employees placed sensitive corporate documents onto home computers that had downloaded P2P software. The FTC has worked with the P2P industry as it has set standards for disclosure and default settings that protect consumers' files and information. We have received reports about the performance of 7 P2P companies and are currently reviewing them to see whether these companies comply with the industry standards. We will make the results of our review public this summer. We also educate consumers about the risks associated with these programs. In addition to a 2008 consumer alert, the FTC's Internet Education website, onguardonline.gov, highlights information about the risks of P2P file sharing software. Finally, we support legislation that requires distributors of P2P file sharing programs to provide timely, clear, and conspicuous notice and obtain consent from consumers regarding the essential aspects of those programs. H.R. 1319 may provide very useful protections for consumers. The agency has worked with committee staff on previous versions of the bill, and we look forward to working with committee staff again regarding this proposed legislation. And we thank you very much for giving the FTC the opportunity to present its views today.
The chair now recognizes Mr. Song for 5 minutes.
Chairman Rush, Ranking Member Radonovich, members of the subcommittee, thank you for the opportunity to participate in today's hearing. The Center for Democracy and Technology is very pleased to see this subcommittee focusing on data privacy and security issues. Based on my conversations with subcommittee staff, I'm going to focus my comments this afternoon on the Data Accountability and Trust Act with just a few words at the end about the Informed P2P User Act. But before I do that, I'd like to make a general point. Both of the bills that are the focus of today's hearing reflect the fact that technology has greatly expanded the ability to collect, store, use, and share personal data. The modern information economy that this makes possible has many benefits, but it also has greatly changed the privacy landscape, and it has expanded the risk of inappropriate disclosure of personal data. Unfortunately, the law has simply not kept pace with these changes. In particular, the United States has no general privacy law establishing any kind of fair baseline of principles or expectations to govern consumer privacy. And in the absence of that kind of overall legal framework, when new privacy issues arise, Congress is essentially left to legislate on a one-off basis without any clear guiding principles and without necessarily much consistency. The result, what we have today, is a confusing patchwork of laws in this area. So based on that, CDT would certainly urge the subcommittee to put a high priority on the enactment of baseline federal privacy legislation, and we're very happy to hear Chairman Rush saying today that he plans a joint hearing and does plan to work on comprehensive privacy legislation. Now I'd like to turn to the Data Accountability and Trust Act. CDT supports the idea of a nationwide data breach notification standard so long as that standard is at least as effective as the laws already in place at the state level. The key point to understand here is that data breach notification is already the law of the land because it is required by all but a few of the states. So from a consumer perspective, replacing state notification laws with a weak federal standard could actually be a step backwards. And even replacing them with a good federal standard still doesn't offer a lot of tangible progress. The principal consumer gains from H.R. 2221, therefore, come from Section 2 of the bill, namely the provisions requiring data security procedures, and especially the provisions requiring information brokers to let consumers review what's in their data broker files. Based largely on these provisions, CDT does support the framework set forth in the bill. My written testimony offers some suggestions for improvements to the bill. For example, the breach notification provisions could be improved by requiring a company that suffers a breach but determines that there isn't enough risk to notify consumers to nonetheless provide a brief explanation to a regulator, basically just to keep everybody honest. For the provisions on security standards and consumer access to information broker files, CDT recommends taking a close look at the scope of those requirements. In particular, the bill uses a definition of personal data that's really quite limited, which may make sense for breach notification provisions, but might make less sense for the provisions in Section 2. Preemption deserves a mention as well. It's important to note that preempting state laws in this area is a very significant step. The only reason we're here talking about breach notification today is that notification laws were pioneered by the states, and especially California. States were able to do that because the Gramm-Leach-Bliley Act preempted inconsistent state laws, but otherwise left states free to experiment. Fortunately, the authors of H.R. 2221 have been careful with preemption. CDT does believe that preemption makes sense for the specific issue of breach notification, and the bill does provide for that. I just say that as the bill moves forward, Congress needs to keep in mind that the price of preemption must be strong federal action, and that overbroad preemption has to be avoided. Overall, CDT does appreciate the careful work of Chairman Rush and the other sponsors of this bill, and we stand ready to cooperate with them on possible improvements as the bill moves forward. Finally, just a couple words on the Informed P2P User Act. CDT absolutely supports the principle that file sharing software should clearly communicate to users how their files may be made available to third parties. Inadvertent sharing of personal files is a very serious privacy matter. As set forth in my written testimony, however, legislating in this area does pose some difficulties. CDT has reservations about the potential unintended breadth of the bill, and also has some reservations about Congress starting down the path of imposing specific design mandates for software developers. That said, we share the broad goal, and my written testimony offers some ideas for modifications to consider if the subcommittee chooses to proceed with the bill. Thanks again for the opportunity to testify.
The chair thanks the gentleman. The chair recognizes now for 5 minutes of opening statements Mr. Holloman.
Mr. Chairman, Ranking Member Radonovich, other members of the subcommittee, I want to thank you for the opportunity to testify today. The Business Software Alliance represents the leading developers of software and hardware of the software that is sold around the world. Roughly 90% of that is from companies who are U.S.-based companies. And our members believe strongly that the type of inquiry that this committee is engaged in today is important, not only to ensure that our customers are using software properly, but also to ensure that the promise of electronic commerce, and equally important, the promise for the type of sensitive data that the government will hold and does hold, that we can have greater confidence, because that will add enormous efficiencies to our system. As we look at the issue of breaches, the data is astounding in terms of the problem that we've seen. I won't repeat all of the information that has been so widely covered in the press and by the subcommittee, except that I will note that the trend is that data breaches are growing. In 2008, it was estimated that there was a 47% increase in data breaches over the prior year. And the average cost of each breach is growing. And for the 9th year in a row, the identity theft has topped the list of FTC consumer complaints, about 26% of all their complaints. And according to the Privacy Rights Clearinghouse, a staggering 270 million records containing sensitive personal information have been affected since 2005. And certainly, we've heard on this panel today, you've heard in your opening statements about Heartland Payment Systems, the single largest fraud-related data loss ever in the U.S., estimates of over 100 million individual credit and debit card accounts were compromised, and the consequences of that have been enormous. And finally, to the point that I made about the importance of government data, nearly 20% of all data breaches involve government, federal, state, and local governments. And as we move to the promise of governments holding even more sensitive data regarding to our health records, as people live longer, as our population grows, as we build the kind of openness and confidence in government, we have to ensure that that important nexus is also protected. With that, Mr. Chairman, I'd like to comment on your pending bill. We believe that this bill, Mr. Rush, makes significant contributions to restoring and building a goal of consumer citizen trust. We support its effort to establish a uniform national standard and provide the preemption of state laws. We also believe that it's important to recognize that it would prevent excessive notification. We do need notification, but not all breaches are equal. And part of what we need both in business, but part of what consumers need, is to ensure that when the notification occurs, it is the result of something that is meaningful. Third, we support exempting from notification data that has been rendered unusable, unreadable, and indecipherable. We would recommend that the limitation in the bill that refers to encryption be broader, so that we're looking at what the test is. And really, this creates market-based incentives that supplement the regulatory authority that's given. It's that combination that will ensure that more holders of data ensure that even if there is a breach, that the party that has carried out the breach or the unlawful entity can't do anything with that data. And that's an important safeguard. Fourth, we believe that your bill takes an appropriate risk-based approach to securing data, and we support the grant of authority and would recommend that it be limited to the FTC and state attorneys general, rather than extending a private right of action. A couple of comments about H.R. 1319. We welcome this effort by Ms. Bono-Mack and other members of the subcommittee to address this issue. Consumer privacy can be and is being compromised because of certain peer-to-peer file sharing applications. We also appreciate this subcommittee's willingness, the committee's willingness, to look at the current breadth of this bill to identify where it could be appropriately limited. We do believe that there are two goals in this. One is to protect consumer security and promote trust, and the second is to ensure that technological innovation continues to proceed. It is this balance that must be struck, and it must be struck carefully. We are all concerned that the bill, if it is in its current form, could pull in some of the very legitimate applications and uses of peer-to-peer technology that are important for every consumer, important for legitimate companies. As it seeks to look at some of the bad actors or some of the peer-to-peer software that we widely know as an anti-piracy organization that have led to the widespread theft of software, music, movies, and other content, we also know that the bill in its current form could sweep in any Internet-aware features of software, such as automatic updates for antivirus software, such as the crash analysis feature of operating systems or the web browsers on our computers. We know that that is not the intent of this bill, but as written, it could reach that breadth. And so we would urge the committee to recognize that while some effort should be made, it is important to enhance security. We also want to ensure that the technological progress and growth proceeds, and that will benefit all users of legitimate software. So on behalf of the BSA, thank you for this opportunity and look forward to your questions.
The gentleman, Mr. Lafferty, for 5 minutes.
Chairman Rush, Ranking Member Radonovich, Subcommittee members, thank you for holding this important hearing. I'm Marty Lafferty, CEO of the Distributed Computing Industry Association. Both of the bills under consideration have far-reaching consequences. Our expertise relates primarily to H.R. 1319. DCIA is a trade group focused on P2P and related technologies. Our mission is to foster commercial development of these technologies so that their benefits can be realized by all participants in the distribution chain, including content rights holders and Internet service providers. We currently have 125 member companies, including P2P, cloud computing, file sharing, and social networking software distributors, broadband operators, content providers, and service and support companies. P2P has evolved greatly in the 8 years since Napster first brought the term P2P file sharing to prominence. Fully licensed ad-supported P2P, subscription P2P, paid download P2P, commercial enterprise P2P, P2P TV, hybrid P2P, and live P2P streaming now deserve to be separated from the narrower subset of functionality associated with file sharing. DCIA member companies increasingly use P2P for the delivery of authorized entertainment and corporate communications content where rights holders, rather than end users, introduce files or live streams for online delivery. We strongly urge the committee to apply the term file sharing without the P2P prefix as a more accurate descriptor for the focus of H.R. 1319. The Committee on Oversight and Government Reform held a hearing on this topic in July 2007 at which one of our member companies testified. Within weeks of that hearing, the DCIA established the Inadvertent Sharing Protection Working Group. Over several months, we recruited participants among leading P2P and other tech sector companies and engaged with FTC staff to address issues associated with unintended publishing of confidential data by file sharers. This effort began by providing demonstrations for FTC staff of how current file share programs work in terms of users uploading material for distribution. It continued through an iterative process involving private sector and regulatory participants to develop a program of voluntary best practices for file sharing software developers to protect users against inadvertently sharing personal or sensitive data. This program was announced in July 2008. Its summary, included in our written testimony, begins by defining terms relevant to 1319, such as recursive sharing, sensitive file types, and user-originated files. It then outlines 7 steps that are required to be in compliance: default settings, file sharing controls, shared folder configurations, user error protections, sensitive file type restrictions, file sharing status communications, and developer principles. The principles address feature disablement, uninstallation, new version upgrades, and file sharing settings. In August 2008, the DCIA announced that compliance monitoring would begin in December to allow developers time to integrate required elements of the ISPG program into their planned upgrades and new releases. Compliance monitoring resulted in reports from top brands that use P2P for downloading, live streaming, open environment sharing, and corporate intranet deployments, and for both user-generated and professionally produced content. Specifically, 7 leading P2P representative program distributors submitted detailed reports to FTC staff in February 2009. In March, the DCIA prepared and submitted a summary. We also noted that software implementations of the popular BitTorrent protocol typically require users to conduct a deliberate conversion process from whatever native file format their content is in to a torrent file before it can be published, thus minimizing this risk of user error. The entire report, plus data tables of individual company submissions, are in our written testimony, but here are highlights. All respondents now have clearly disclosed install default settings that only permit sharing files downloaded from the network. They do not share user-generated files by default. 100% also provide complete uninstallation of their file sharing software that's simple to do and explained in plain language, for example, by using the standard add remove program in Windows. And 6 out of 7, which is all where this is applicable, now offer a simple way to stop sharing any folder, subfolder, or file by using easily accessed controls. In April 2009, subcommittee staff invited the DCIA to participate in redrafting H.R. 1319. We formed a DCIA member subgroup to conduct this work. The process is underway, and we'll be glad to coordinate that work with staff. Among our greatest concerns is that the bill, as drafted, would have unintended consequences. The present draft goes way beyond the specific concerns discussed here and would apply to additional functionality and technologies that have nothing to do with recursive sharing of sensitive file types. Applying these requirements to numerous products, services, and companies would be burdensome and counterproductive. To the extent that legitimate consumer concerns persist in the area that the bill intends to address, we strongly believe they can best be handled by ongoing self-regulation under the oversight of the appropriate federal authority as we initiated with the ISPG. The bill as constructed would unnecessarily burden U.S.-based technology firms with innovation freezing constraints while being unenforceable against overseas competitors' software is available to U.S. consumers. The great concern also is how it might stifle yet undeveloped new and potentially very useful and valuable software applications. On the other hand, the DCIA has committed to self-regulation through the ISPG to address the subject matter of this bill and is making substantial progress. So rather than a problematic new legal measure, we believe that formalized requirements for compliance with that process will be more effective in achieving the purpose of the bill. We look forward to working with the subcommittee on these issues in a productive manner that will benefit all your constituents. Thank you for your continued interest in our industry.
The chair thanks the gentleman. The chair now recognizes Mr. Pratt for 5 minutes for the purposes of an opening statement.
Chairman Rush, Ranking Member Radonovich, and members of the subcommittee, thank you for this opportunity to appear before you today. My name is Stuart Pratt, President and CEO of the Consumer Data Industry Association. Our 250-member companies provide our nation's businesses with data tools necessary to manage risk and a wide range of consumer transactions. And these products include credit and mortgage reports, identity verification tools, law enforcement investigative products, fraud check transaction identification systems, decision sciences technologies, location services, and collections. My comments today will focus exclusively on H.R. 2221. And we applaud its introduction. CDIA's members agree that sensitive personal information should be protected. We also agree that consumers should receive breach notices when there is a significant risk of them becoming victims of identity theft. Our members agree with the Federal Trade Commission recommendations, which embrace these two concepts. I would only add that if a federal law is to be enacted, it should be a true national standard. We believe that data security and breach notification provisions in H.R. 2221 would be most effective if they were better aligned with requirements found in other current laws. Alignment is key to ensuring that all who are affected by the Act are successful in complying with new duties under data and also with their current duties found under other laws such as the Fair Credit Reporting Act and the Graham-Leach-Bliley Act. Let me discuss some of the ways that 2221 interplays with existing duties found in current laws. Section 5.6 defines the term information broker. Absent aligning this definition with other current laws, our members' products will be affected. This bill would require information brokers to have reasonable procedures to verify the accuracy of personal information, provide consumers with access to these data, and ensure a system by which consumers can dispute information. All of our members operate consumer reporting agencies as this term is defined in the Fair Credit Reporting Act. They produce data products defined as consumer reports. Consumer reports are used to make determinations of a consumer's eligibility for a service or product, and the FCRA establishes duties for accuracy, access, and correction. as it relates to these products. Our members agree that where data is used to make a decision regarding consumers' eligibility for a product or service, consumers should have these rights. Since there are similar duties under the FCRA and data, we propose the definition of information broker should be amended to exclude the term consumer reporting agency. And while we appreciate the inclusion of Section C3C, which attempts to address our concern, we believe that since the FCRA's duties are well understood and the FTC has direct enforcement powers, that we should have a complete exemption. Regarding disclosure, Section C3 allows an information broker under certain circumstances to not disclose personal information to a consumer. The section does not exempt an information broker's fraud prevention tool from the duty to verify accuracy, however. Fraud prevention tools are designed to identify the possibility of fraud, and to apply an accuracy standard to fraud prevention tools is unworkable since these tools are designed to warn a lender or a utility or other business about the possibility of fraud. Fraud prevention tools consider how data is been used in previous identified cases of fraud and employ many other relational strategies. We would urge the expansion of C3B3 to include fraud prevention tools so that they're completely exempted from the accuracy standard requirement, not because the tools are designed poorly, but because these tools cannot line up with an accuracy standard in the first place. Your bill also, as indicated, establishes both a requirement for data security and a requirement for security breach, and we have absolutely no qualms about either of those requirements. Our members, in fact, comply with those types of requirements today, and our only request is that where our member companies are already operating as a consumer reporting agency under the Fair Credit Reporting Act, or where they're operating as a financial institution under the Gramm-Leach-Bliley Act, that they would be exempted from these data security and these security breach notification duties because they already have those duties under the Fair Credit Reporting Act and also under the Gramm-Leach-Bliley Act, and in particular the safeguards rules, which include breach notification. So this process of alignment will make this bill more effective. If we can make this truly a national standard, you certainly will have filled some gaps along the way. I think that Mr. Sohn said it very well. In the meantime, we live with a range of state laws. We have worked constructively with many, many states in establishing those statutes and in establishing definitions of the crime of identity theft. And we will continue to do that, and we look forward concurrently to working with you in the committee. Thank you.
Thanks, the gentleman. And now the chair recognizes Mr. Rotenberg for 5 minutes.
Mr. Chairman, Mr. Radonovich, members of the committee, thank you very much for the opportunity to be here today. EPIC is a nonprofit research organization here in Washington. We have a particular interest in this issue of security breach notification. EPIC was the organization that had urged the Federal Trade Commission to investigate the data practices of a company called ChoicePoint, because we believe that that company was making the personal information of American consumers vulnerable to misuse. The FTC did not heed our warning, and instead we all read in the newspapers when an investigation broke in Los Angeles that revealed that the records of 145,000 American consumers had been sold to a criminal ring engaged in the act of identity theft. I promise you, after that news story appeared, the FTC and many state attorney generals became very interested in this problem. Now, we learned of the problem with ChoicePoint in part because of a good law that had been passed in the state of California, which required companies that suffered from a security breach to notify people who were impacted. And as a result of the ChoicePoint notification, many other states began to understand the need for security breach notification. Now, this has been an evolving process. I think there are now 44 states in the U.S. that have security breach notification. And while we certainly support an effort to establish a high standard across the country, I do want to warn you that one of the consequences of this bill would be to effectively tie the hands of the states from further updating their laws or enforcing stronger laws. And I think this would be a mistake. I read recently, for example, that the California State Senate has just approved new changes to its notification law that would provide individuals with better information about the type of personal information that was improperly disclosed and how it might be misused. This need to be able to continue to update security breach notification, I think, should be a consideration as the committee looks at legislation to establish a national standard. One of the other points I'd like to make about the legislation concerns the relationship in the realm of notification between the individuals who are impacted and the role of the Federal Trade Commission, which is also notified under the bill. There is understandable concern that if individuals receive too many breach notices, they will serve no purpose. And so there's a need to set a standard so that people are not receiving lots and lots of these notices which they'll come to ignore. But with respect to the role of the Federal Trade Commission, I think the bill could be strengthened by requiring companies in all circumstances to notify the Commission where substantive breaches have occurred, and moreover, to put on the Commission an obligation to be more transparent about the information that it receives regarding the problems of breach notification in the United States. There is also a risk with the legislation as it's currently drafted that the FTC will obtain information about security breaches, may choose not to act on the information it receives, and that information will effectively remain secret both to the public and to this committee, and the problem will continue to grow. So I hope that is an area that can be considered as well. We talk also about the safe harbor provisions, essentially companies that have certain security practices, such as encryption, should be encouraged to put in place and maintain those practices. But again, we think that notification can be made to the Federal Trade Commission in those instances where security breaches occur, even if it may not be necessary to notify the target population. Finally, I'd like to point out that since when the bill was originally introduced, there have been significant changes, both in the Internet and also in communications technology. Facebook, for example, now has 200 million users. 4 years ago, when this bill was first considered, there were many, many fewer people using these social network services. This has two implications. First of all, there is a new way to notify people online. It's no longer necessary to talk just about a website, but also a social network presence. It also means that there's a new risk in data collection that needs to consider the growing significance of social network services. And finally, I might mention that text messaging has become a very effective way to notify people about things that might concern them regarding security. We propose in our testimony that where possible, text messaging be used as a supplement to the other notification procedures, including mail and email. So thank you again for the chance to testify, and I'd be pleased to answer your questions.
The chair now recognizes Mr. Moback for 5 minutes.
Chairman Rush, Ranking Member Radonovich, and distinguished members of the committee, I thank you for giving us the opportunity to testify here today. As many of you discussed in your opening statements, the security risks associated with peer-to-peer, our company, Tyversa, of which I'm the CEO of, has a unique insight on this, in that Tyversa has the unique technology that allows us to span out globally to see all information that's occurring on all the peer-to-peer clients. So it's not just a LimeWire or a Kazaa or a BearShare, it's everyone, all-encompassing, and we see it in real time. So therefore, this provides us a great insight to provide information to the committee here today. This information that we're finding is very sensitive. There are security measures, so I commend the Honorable Ms. Bono-Mack for bringing this here today. The reason why is that many security professionals around the world in high-ranking positions in corporations in the United States and abroad aren't even aware of this. So again, for her insight to bring this to the committee and bring 1319 forward, it's very important because again, the awareness is still not where it needs to be. For instance, in the last 60 days, despite the measures that have been taken by the peer-to-peer clients, despite which I also admit are improving. LimeWire is improving its its protocols to decrease the amount of breaches that have happened. But in the last 60 days, Tyversa has downloaded breaches in the amount of 3,908,000 breaches, individual breaches, in the last 60 days. I find it very important that 2221 and 1319 are actually discussed on the same day. The reason why is this is where breaches are happening. As Mr. Gringy of Georgia called out, obviously we all saw the Wall Street Journal article April 21st about the Joint Strike Fighter. It wasn't reported in the Wall Street Journal. This was peer-to-peer. The information, unfortunately, is still on the peer-to-peer. This was discovered in January 2005. We discovered it. We reported it to the DOD. It's still here. It's still out there. It's never been remediated. Awareness is not where it needs to be. Oversight is not where it needs to be in order to address these problems. That's the type of national security ends. Now, there are also the consumer ends. From Tyversa, we process 1.6 billion searches per day. Every day, Google is about 170 million per day. So we were about 9 times what Google is processing on a daily basis. In those searches, we're able to see what the users are looking for around the world. And in those searches, we see people searching for your financial records. They are not looking to apply for a credit card. They are not looking for health insurance. They're looking for your health insurance because they want to quickly go online and buy online pharmaceuticals using your medical insurance card as medical identity theft. No credit monitoring will stop that. They want to get your Social Security number filed with your tax return. We did a study with a live show with the Today Show showing that in that instant, 275,000 tax returns were found in one search on the peer-to-peer. So a minimum of 275,000 Social Security numbers on one time. Now, we've done other searches where it's been over 500,000 on one time. And yet, I would also say, strongly urge the FTC that on the website where it would identify to users that this information is coming from the peer-to-peer, there's not one mention of peer-to-peer on where are they getting your information. 9 million victims every year of identity theft, and the number one mention on the FTC's website is dumpster diving. It doesn't add up. The numbers don't add up to dumpster diving. Consumers are not aware of this problem, not from a national security standpoint. Executives don't know it. Security executives do not know this problem. Consumers aren't aware of this problem. They need to know that their information is out there and it's being sought after on an enormous scale, such that even in our research in the last few months, we've had a 60% increase in searches for information that will lead to identity theft and fraud. This is a serious growing problem that consumers, again, are not aware of. So we applaud 2221 for a national breach. I will tell you that as we find these breaches, these 3,900,000 breaches, as evident as we can, we return the information and alert the companies to the breach. Again, we do it out of our duty of care policy. There are no strings attached to that. I will tell you that there are thousands of cases that our individuals, our employees have provided to users, to companies nationwide, that they completely disregard the breach. Many of those are actually cited in my written testimony. So you would think that you're safe if you do not use peer-to-peer. Well, I will show you in the written testimony, there are users out there that all they did was go to the hospital and they provided their information there. And now that's one of the things. So individuals need to have an identity theft protection service as well as a national breach notification such as 2221. And I thank you for the opportunity and welcome questions.
Thank you very much. Now the chairman recognizes Mr. Sittner. Mr. Sittner, you're recognized for 5 minutes for opening statements.
Thank you, Chairman Rush, Ranking Member Radonovich, and members of the subcommittee. My name is Tom Sidnor, and I'm a senior fellow at the Progress and Freedom Foundation. I'm here speaking today on my own behalf, and I'm also the author of 2 studies on the causes of inadvertent file sharing file sharing programs and technological features to induce users to share, published by the United States Patent and Trademark Office, and Inadvertent File Sharing Revisited, published by the Progress and Freedom Foundation. And I'm here today to testify in support of H.R. 1319, the Informed Peer-to-Peer Users Act.
Mr. Sitnor, would you please excuse me just for a moment? I wanted to alert the members. It's a little over 5 minutes for this is a three-series vote. There are 3 votes in this series, and that would be the last votes of the day. So if members want to leave to go and vote, after this witness completes his opening statement, then the chair will recess the committee and reconvene at the conclusion of this series of votes. So we ask that the members please return promptly so that we can complete our questioning of these witnesses and complete this hearing. Mr. Sitner, would you please continue?
Thank you, Mr. Chairman. And I'm testifying today in support of the bill because my written statement and my past published work on inadvertent sharing, I think, shows that in the past we have tried to rely on voluntary self-regulation, and it has failed. Voluntary self-regulation should be an incredibly important part of our technology policy, and for that reason it must be taken seriously. Unfortunately, in the context of distributors of file sharing programs used mostly for unlawful purposes, it has been tried, voluntary self-regulation. It has failed miserably in the past, and I can report that it is failing again right now. I want to consider, for just as an example, the file sharing program LimeWire 5. The DCIA has hailed LimeWire 5 as the gold standard for the implementation of its new voluntary best practices. And LimeWire itself has, as a result of this hearing, generated great publicity for itself by telling Congress that at long last, LimeWire 5 put the final nail in the coffin of inadvertent sharing of sensitive files. And the problem is that last statement is not even arguably correct. And to show why, I want to consider a hypothetical based upon the recent reports from Today Investigates, showing that in New York State alone, researchers could find over 150,000 inadvertently shared tax returns. The report also showed the real-world consequences of inadvertent sharing by profiling the Bucci family, who had their tax returns stolen by an identity thief because they had inadvertently shared their tax returns because their preteen daughters were using a file sharing program reported to be LimeWire. But the real problem in such a case is that a tax return is really only the tip of the iceberg. Such episodes usually mean that a family is sharing all of its personal data files stored on the family computer. All of the parents' work and personal documents, scans of legal, medical, and financial records, scanned documents providing identifying information about the family's children, all of the family's digital photos, all of its home videos, an entire music collection, probably thousands of files. Now, consider two families that have been affected by this type of catastrophic inadvertent file sharing, and just assume it was caused by an earlier version of LimeWire. Consider what happens if they upgrade to LimeWire 5. One family doesn't know they have a problem. They are unaware that a problem exists, but they hear reports that LimeWire 5 has ensured the complete lockdown of the safety and security of LimeWire users, and so they upgrade to LimeWire 5. Will that correct their inadvertent sharing of sensitive documents problem? It will not. By default, simply by being installed, the family will continue to share documents that are, by any definition, a reasonable definition of the word, sensitive. They will continue to share the family photo collection. They will continue to share scanned legal, medical, financial records, perhaps even tax returns. They'll continue to share data about their children. They will continue to share all their family, their home videos. They will continue to share their entire music collection. And so they will continue to be exposed to the full range of risks: identity theft, data on their children getting into the hands of the pedophiles that use these networks, and the risk of a lawsuit. Now, the other family does know their problem. They detect it, and they resolve it by uninstalling LimeWire, remove it from their computer. So this family actually has put the final nail in the coffin of their inadvertent file sharing problem. But they hear about LimeWire 5, their kids reinstall it because now it's completely secure. What will happen? By default, simply by being installed, that program will revive, will call back from the dead, the family's inadvertent file sharing problem. It will automatically begin resharing all the data files that were shared before, except for some types, simply by being installed. That is not acceptable behavior. It is not acceptable practice, and I think it indicates why we need to, why the committee should be commended for its work on H.R. 1319. Thank you.
The chair thanks this witness and all the witnesses. Now the chair will ask that this committee stands in recess until such time as we return from a series of 3 votes. I would ask the witnesses, if you please would wait so that the members can come back and ask questions. Thank you so much. The committee is in recess. The hearing will now come to order. The chair recognizes himself for. The chair recognizes himself for 5 minutes for the purposes of questioning the witnesses. I'd like to start out with some very simple questions to get on the record how the witnesses review the legislation we're contemplating today. And I'll just ask each and every one of you if you would just answer with a yes or no. Answer if you can, or if you can not, then give me a very brief explanation of your vote, of your answer. Just finished voting. So my first question is, with regard to H.R. 1319, do you support the legislation in its current form? If not, do you support the intent of the bill with revisions? And my second question, you can answer both of these together. Do you support H.R. 2221 as it is currently drafted? If not, do you support the intent of the bill with some revisions? I start with Mrs. Harrington. Would you push the button?
The Federal Trade Commission strongly supports the intent of both bills. We would like to continue working with committee staff on revisions to each, but we're particularly supportive of the enforcement authority and tools that both bills give the FTC and civil penalty authority.
Thank you. Mr. Song.
CDT has significant reservations about H.R. 1319 as drafted, but we certainly support the intent. We do think it may be tricky to figure out the drafting details, but we're certainly happy to work with the committee on that. On H.R. 2221, we generally do support the bill as drafted. There's some modifications we've suggested, and we absolutely support the intent.
Thank you. Mr. Holloman?
I actually agree fully with Mr. Sohn's comment that we support the intent of both bills. We have some recommendations in our written testimony, believe strongly that action is needed. I think it may be more difficult to make some of the definitions in 1319, but are certainly eager to work with the committee to ensure the intent is fulfilled.
Mr. Lafferty?
I'll just speak to 1319. We absolutely support the intent of the bill, the clear, conspicuous notice, and the informed consent for very important file sharing modalities that could have major impact on consumers. We just don't think it can be legislated. We've worked hard to try to come up with suggestions for a redraft, and it's very difficult to get the language not to reach out and touch other kinds of technologies and future software applications that would be impacted and disadvantage U.S. firms from overseas competitors. So we support the intent, but not the language.
Mm-hmm. Mr. Pratt?
The CDI has no position on H.R. 1319. With regard to H.R. 2221, we certainly support the intent. We've outlined in our written testimony a range of suggestions about how we could align the bills with other federal laws, and if we could accomplish that goal, I think we'd feel more comfortable with the final work product. Thank you.
Thank you.
Mr. Chairman, we do support the intent of H.R. 2221 and generally support the legislation as drafted. We have a number of suggestions in our testimony for how to strengthen it. With respect to 1319, we don't have a position for or against the bill. With respect to the intent behind 1319, we think it may be possible to get to some of the concerns regarding security through other legislation, but we would certainly be happy to work with the committee to see how it can be accomplished.
Mr. Bobak.
Mr. Chairman, we strongly support both 2221 as well as 1319 in clearly raising awareness and providing some responsibility and structure to a very needed process both on the peer-to-peer as well as just data breach, federal data breach notification.
Mr. Chairman, I'll confine my comments to H.R. 1319. Yes, absolutely strongly support the intent of the bill. I'm aware of that there are legitimate concerns about making sure that we don't necessarily sweep in entirely, and potentially entirely legitimate uses of peer-to-peer technology, and would be happy to continue to work with the committee and anyone else to try to get to a place where everyone is comfortable.
Chair thanks the witnesses. The chair's time is concluded. The chair now recognizes Mrs. Bono Mack from California for the 5 minutes for questioning.
Thank you. I thank the chairman and our panelists also for your time today. Mr. Lafferty, I'd like to read to you a bolded warning in the user guide on the LimeWire website entitled, "Using LimeWire and P2P Software Safely." The warning states, I quote, "Please ensure that any folder on your computer that contains personal information is not included on your LimeWire, in your LimeWire library," end quote. So tell me, Mr. Lafferty, if I were to complete a default installation of LimeWire 5.1.2, what files and folders will the mere installation of the program include in my LimeWire library?
With the LimeWire 5 and later versions of LimeWire, sensitive file types, which are a large number of extensions of files to protect your spreadsheets, your Word documents, PDFs, things that might have sensitive data, are unshared by default. So I would completely refute the testimony of Tom Sidner earlier. It just isn't true. When you, in either example that he gave with a family that kept just upgraded the version, or the one that uninstalled it and reinstalled it, in both cases, all of the sensitive file types are unshared by default. It's over. They're no longer accessed or shared. To reshare any of those files, you'd have to individually take the file and go through, ignore several warnings to put those individual files into the mode where they could be shared, and then be asked whether you want to share that with specific friends or the network at large. So LimeWire 5 has done away with the concept of shared folders, really, and now it's a file-by-file.
There's specific warnings. What do they say? And it is not, it's still actually sort of an inherent default. You have little boxes that come up, that I believe there are 4 different boxes that are there, and one does say My Documents. So you just said that that could be an Excel spreadsheet, which in fact would probably be saved under a My Documents folder, would it not?
If you chose to put the My Documents folder into a shared mode, it would still
Is that the
unshare.
default for an Excel spreadsheet for the standard user?
I don't understand the question.
Where is a default Excel spreadsheet saved on your computer, on your hard drive? Is it not necessarily defaulted to My Documents?
It's probably different for every person, but the point is...
Probably different. What is the default? What is the default? Where does Mr. Sidner, perhaps you have the answer to that. I'm happy to...
It doesn't really matter where it is. That file type won't be shared.
How could it not matter,
LimeWire.
with all due respect, how could it not matter where it is? That's the root of the whole problem here.
Because it won't be shared.
Unless you check simply one of the 4...
Unless you choose that individual file, if it has that Excel spreadsheet.
That individual file.
Individual
Mr. Sidner,
file. Correct.
do you care to comment on that?
That's correct.
Yes, that's not quite an accurate statement about how the LimeWire My Library feature works. My Library is in LimeWire 5. In LimeWire 5, it basically are the set of documents that are going to be managed in LimeWire, and thereby that set of documents is going to be much easier to share because they are going to be in the library, and there will be a button to click to share them. Now, and that's why the LimeWire User's Guide has the warning that you read. Please ensure that any folder in your computer that contains personal information is not included in your LimeWire library. Now, by default, when you install LimeWire 5.1, and I did it last night again, the default option is to have LimeWire put all of the files stored in your My Documents folder and all of its subfolders into the LimeWire library. That alone will not share them, but it will make them available for sharing and much easier to share, and therefore the behavior of the program is simply not consistent with the advice in the user's guide. As to my testimony earlier, it was quite correct. The difference, the reason I think we're getting confused is when I say sensitive files, I mean files that would actually be sensitive to share over a network like Nutella. So if you have a scan, for example, scans of your family medical records and tax returns, those are going to be stored in image file formats often. And those will be shared by default. LimeWire will, and if you upgrade to LimeWire 5, it will continue to share those file types if you were sharing them before. And if you install LimeWire 5 on your computer and a previous version of LimeWire has ever been there, then it will automatically begin resharing files that were shared previously. So simply installing the program can indeed resume sharing of files, even if you're installing on a version of on a computer where there's no version of LimeWire currently installed. I'm correct about that. I reran the test again this morning before the hearing.
Thank you. I know my time has expired, and I hope we have a second round. Thank you, Mr. Chairman.
The chair fully intends to have a second round. The chair now recognizes the gentleman from Georgia, Mr. Barrow, for 5 minutes.
I thank the chair. I want to try and get my arms around the inadequacy of the current situation and talk about what it is this legislation proposes to do in order to try and alter the situation for the better. Ms. Harrington, am I correct in understanding that there are very limited tools available to the FTC right now to deal with this issue, that basically the only option you've got under current law is to initiate a specific enforcement action against somebody, a fact-specific action based on a specific instance, and that basically you're pretty much limited to, is it injunctive proceedings? Is that about the extent of it?
That's right.
No civil penalties whatsoever?
No civil penalties.
No rulemaking authority, no prescribing of proper procedures or best practices. You just got to go after individual cases, and all you can do is tell folks to stop doing what they're doing when you prove that they've done it.
The rulemaking authority available to the Commission is under the Magnuson-Moss amendments to the FTC Act, and those are laborious and take a very long time, the procedures to use.
So what we're proposing to give the FTC under 1319 would give you all some authority you don't have right now. Let me ask you, are the civil penalties helpful to you all in trying to bring some order to this situation?
There are two things that are helpful. Civil penalty authority is very helpful, and also to the extent that some practices in these very fact-specific situations might be injurious but neither deceptive nor unfair, then having additional statutory authority is very helpful.
Earlier on in the testimony, we heard some folks raise some issues about the international end of things. We all know we're connected to a World Wide Web, and that any effective regulation of this marketplace in our country is going to involve dealings with folks who can cross the boundaries in cyberspace pretty much at will. What's your concern about, if not the extraterritoriality of the law, the extraterritorial effect of us being able to regulate this? How do you think we can address that supposed shortcoming of us attempting to regulate this on our own shores?
Well, first of all, the subcommittee was instrumental in giving the Commission additional authority under the U.S. Safe Web Act, which we use to get information about overseas targets and to enlist help from other governments, and that's very useful. But that said, if there are overseas software providers who are making available file sharing software that is injurious to U.S. consumers, we can certainly assert our jurisdiction over those practices that occur within the United States, but we may not be able to reach their purveyors if they're in other countries, and particularly in countries that aren't particularly interested in helping out. One of the things that we're very concerned about is that the dominant players in this industry, which are in the United States, do the best thing and the right thing. And we think that setting some legislative standards, such as the ones that are set forth in the bill, would really help. We want the U.S. players to be the best players so that they continue to be the dominant players and the ones that consumers can use with some confidence.
The impression I get from what you're saying, and this is how I hear what you're saying, is that if we police the marketplace where everybody shops, we don't have to worry about the marketplaces where very few people shop or hardly anybody goes. Is that a fair way of putting it?
Well, we certainly should police the marketplace where everybody stops if that marketplace is subject to our jurisdiction.
But the high volume
And-
users, the ones who got the lion's share of
Yes.
the market, if we can make sure that what they're doing is right and appropriate, and folks who trade at these places will not have to worry about losing their stuff. We don't have to worry quite so much about those areas that might be hard to reach. Why strain at a gnat and swallow an elephant in the process?
That is certainly the intention. There is always a risk that overseas operators can gain in market share in the United States by doing, by gaining some sort of competitive advantage over the regulated entities in our marketplace. But that's not a worry right now that's keeping me awake at night.
Thank you. I'll wait for a second now, Mr. Chairman. Thank you, ma'am.
Thank you. The chair now recognizes the gentleman from Louisiana, Mr. Scalise, for 5 minutes.
Thank you, Mr. Chairman. Really kind of open this up to the whole panel on H.R. 1319. Do you think this will help prevent illegal use of peer-to-peer software, including stealing personal records, copyright violations, and things like sharing child pornography? You can just go down.
I think it'll help under some circumstances, and under others, we need more. The data security bill actually could be very helpful here too, because as I mentioned in my oral statement, there are really 3 scenarios where sensitive information is shared. One is when consumers don't know, don't understand, and this bill will hopefully would go a long way, I think, there. It's not going to help when the problem is malware. And it's not going to help when the problem is a business that has not prohibited and barred from its system and its computers file sharing software. And it's not going to help if the problem is that an employee of a company takes sensitive information home and puts it on his or her computer, and that computer has file sharing software or malware on it that extracts that. So it's going to go a long way to help in scenario 1.
Anybody else want to touch on that?
Yeah, I'll just say I do think the intent and the focus of the bill is certainly on the inadvertent disclosure, so that the privacy-related concerns, I think that would be the main impact and is the main thrust of the bill.
Let me ask about the data breaches that have occurred. I think FTC had dealt with it, the largest one I've seen, the TJX, which I think initial estimates were about 45 million Visa, MasterCard records were breached. Ultimately, it turned out somewhere close to 100 million were breached, and y'all had brought charges against them and subsequently other companies. Is there now an industry standard for data protection? What's your feeling on where we are today versus some of those cases a few years ago?
Well, there are certainly well-established good practices that in the cases that we've brought were not followed. For example, downloading available patches, preventing against well-known attacks and kinds of attacks are well settled. Necessary practices. They're not even best practices. They're necessary. And those companies did not follow those practices.
Anybody else want to add anything to that? We're getting into now an area of moving towards electronic medical records. There was some funding and language in the stimulus bill to start going down that road more as people's health information gets put on the web more and more. What kind of protections are there today? What kind do we need, whether it's in either these 2 bills or in other vehicles, to protect people's health records as they become available on the internet so that they're only available to the doctors who need to be reviewing them?
Well, the Recovery Act also directed both the FTC and the Department of Health and Human Services to do rulemaking to set standards for breach notification when consumers' sensitive health information is placed at risk. The FTC, as I mentioned, has just issued a proposed rule dealing with personal health records and other non-HIPAA covered entities that may have this sensitive information to set breach notification standards. And we're continuing also to work with HHS to do a report that is due back to Congress in a year on these issues.
Any of y'all doing any work on that issue, Mr. Bobart?
I'd like to also comment on that. There are no standards as far as peer-to-peer notifications. There are no standards as far as peer-to-peer security measures. In fact, most companies don't even have any standards on peer-to-peer. When asked, most corporations, large and small, what information they're doing about peer-to-peer, most people, if they respond at all, will say that they are blocking peer-to-peer and that they have a policy against it. That's the extent of it. And I will tell you that, or they'll say that they have a firewall or an encryption, of which nothing, firewall does not stop peer-to-peer, encryption does not stop peer-to-peer, intrusion prevention, intrusion detection, and all the standard security measures do not stop peer-to-peer disclosures from happening, which is why in the past 60 days we've had over, almost 4 million disclosures of this type via peer-to-peer, because there's just no standards.
And finally, Mr. Holliman. Well, Holliman.
Mr. Scalise, we believe that the incentives that are in Chairman Rush's bill that would encourage a marketplace to grow for companies who hold sensitive data to use proper security technologies to make that information inaccessible to anyone who might actually breach it, those market-based incentives is a great supplement to the enforcement authority that the bill would give. So we think the two together can be effective.
Thanks. I yield back, Mr. Chairman.
The chair intends to engage the members of the committee in a second round of questioning, and we'll allow each member an additional 2 minutes for the second round of questioning. The chair recognizes himself now for the second round and allocates 2 minutes for the purposes of questioning. Mr. Rothenberg and Mr. Song, is the definition of, quote, personal information under H.R. 2221, is it adequate in terms of data security? The bill only addresses financial information. Should we also consider requiring companies to secure sensitive information, such as medical information or passport numbers or et cetera? I mean, should we expand the definition of personal information?
Well, the bill has several different components, and I think for purposes of the breach notification component, the definition there is fairly close to what's been done in a lot of the states, and it reflects a lot of what's been common in the data breach notification area. I think for purposes of something like security standards, asking companies to have reasonable procedures in place to protect data, there's no reason to restrict it to the rather narrow set of data that's in the definition of personal information now, because it's currently in the bill only applies if it's not just name and address and some other information that'd be enough. There actually has to be either a social security number or a financial account number plus password or a driver's license number, something like that. So I do think that the bill might consider using a broader definition of personal information for some purposes and the narrower definition for others.
Yeah. Mr. Chairman, in my written statement, I made a suggestion on this issue of personal information. I do think it's appropriate to have a broader standard and also to recognize that some of the personal identifiers nowadays aren't just limited, for example, to a social security number or driver's license number. There are other types of personal identifiers like a Facebook member number or even the IP address associated with your computer that needs to be incorporated as well. So I think those changes can be made both to get to more circumstances where the bill should reach and also new types of identifiers.
Chair thanks the witnesses. Now the chair recognizes the gentlelady from California for 2 minutes for additional questions.
I thank the chair for the second round. Mr. Holliman, you testified that the P2P bill would cover more than just the illegitimate purpose software. You identified a number of legitimate uses of P2P software, such as bicoastal collaboration on projects. I think you actually mentioned Palm Springs to Chicago airports collaborating. So this is, of course, when used correctly, beneficial use of P2P software. So we all agree that this technology can be extremely helpful, but if such programs are covered by H.R. 13, what is the harm? How is notice and consent an issue? Back to the Palm Springs, Chicago, I think, yeah, I could see them collaborating on plans, but I don't think they necessarily want to collaborate on payroll numbers, the like. So how is notice and consent an issue in this case?
Ms. Bonovac, our sense is that there is a rapid growth in the legitimate uses of P2P, and that it will become a de facto part of how we use technology that most people will want to use. So our sense is as that part of the market grows, we want to ensure that the legislation doesn't overreach to get into things which all of us would generally agree would not necessarily need, I mean, an initial notice that that's there is fine, but the process of how you would then disable that needs to be clarified.
Which is growing faster, illegitimate or legitimate uses?
I think our sense as technologists is, and I'm not a technologist, I play one on TV, but not as technologists, but our engineers in our companies believe that the legitimate purposes of peer-to-peer in the next 10 years will certainly grow much faster than the illegitimate.
In the next 10 years, quickly in 10 seconds, Mr. Boback, which has grown faster, legitimate or illegitimate uses?
I would tell you that legitimate uses are now emerging. So while there's still a growth at this point because the awareness is still decreased and there's not enough awareness as to the problem, the legitimate uses and the distribution content is an absolute must going forward. So I am a supporter of peer-to-peer. However, the security measures, just as in the early stages of the World Wide Web, need to be addressed as in your Bill 1319.
Thank you.
The chair now recognizes the gentleman from Georgia.
I thank the chair. I think Ms. Bono-Mack is getting to the heart of the issue on the peer-to-peer legislation. If I could reframe the issue, we want to fix what's broke with this system. There is stuff out there that's inside this legislation's definition of peer-to-peer file sharing program that is malicious. There is stuff out there that's inside this definition that is perfectly benign. Mr. Holliman and Mr. Sohn, I'm going to pitch this one in y'all's direction. How would y'all define what we're getting at in such a way as to stop the bad stuff and allow all the other stuff to continue without having to have a proliferation of warnings and opt-outs that basically hobble this technology before it can even get started? Who wants to take a shot at how you would define this in order to be able to reach the stuff we want to reach?
I'll start on that, Mr. Barrow. In our testimony, we've actually listed 5 ways in which we would modify the definition in the bill, and believe that if those types of changes are made, that would be useful and would help it preserve the intent of the bill, including looking at the type of purposes that the peer-to-peer file sharing program is typically used for, going at many of those things like copyright infringements, which are a huge source of concern to.
Is that an effective way of defining it, though, so that the regulators can get at what's going on and so the technology can take care of
We
itself?
actually think that the regulators would, their hand would be strengthened by more precision in the definition rather than the breadth that's in there currently.
Mr. Sohn, what do you think?
I also set forth in my testimony some ideas on that point of how you might make this more narrow and apply to what we think of as file sharing software. I agree with Mr. Lafferty's testimony that the key here really isn't peer-to-peer. Peer-to-peer is a kind of architecture. It's really about file sharing functions that could enable documents and other kinds of files on a user's local computer to be made available to third parties in bulk, and third parties that haven't been selected or aren't even known to the user. And so we proposed 4 bullet points of items that we think could be in a definition, but it tends to focus on that, the ability to share files with unknown parties with no intervening action or knowledge or selection by the user in terms of who that file will be shared with.
Mr. Chairman, my time has expired, but I'd like to ask the witness to go beyond that and actually be prepared to work with counsel on our staff to see if we can actually come up with some concrete language to accomplish this. Thank you. I yield the mic.
The chair now recognizes the gentleman from Louisiana for an additional 2 minutes.
Thank you again, Mr. Chairman. This might not necessarily be these 2 bills might not be the vehicles for it, but they might. it's been a problem for years, especially with identity theft getting worse, with so many documents and authenticators that use Social Security numbers, that require Social Security numbers to be used, or documents that are public record that still require people to use Social Security numbers. A number of states have gone on their own and tried to ferret those out and prohibit Social Security numbers on public documents, but it's not universal. There is no real standard still. I think there was standalone legislation, might have been in the last Congress, that really didn't go anywhere. But is there a way that we can have some kind of standard to protect people's Social Security numbers so that they're not required for certain documents or authenticators, so that they're not so easily obtainable by third parties that are trying to take them for bad purposes? Kind of open it up, start off with Ms. Harrington and anybody else that wants to take a shot.
Well, as part of the President's Identity Theft Task Force work that we've been engaged in, there are a couple of important initiatives that we're supporting. One, the task force brought about a government-wide examination of government uses of Social Security numbers with the goal of minimizing to circumstances where the number is absolutely essential. Federal government agencies' use of Social Security numbers, and I think a lot of progress has been made in the government on that. Number two, the FTC, as part of the Identity Theft Task Force work, convened a workshop and has continued to work on the question of authentication and how better authentication procedures and technologies can be developed so that something like the ubiquitous Social Security number is no longer needed. But there are lots of commercial settings where both, right now, where both consumers and businesses benefit from the use of Social Security numbers and may need them. And until we have much better authentication measures available, it's a very tough question to answer, what to use instead of Social Security numbers. For example, consumers have really benefited in many instances from being able to quickly get a loan to get a car. That whole credit reporting system depends on Social Security numbers, and you know, we need a replacement, but we don't have one yet.
And at least in the government sector, where we can set up a mechanism where people aren't required to have it on a document that's public record, because clearly in the government arena there are records that are public, and some of those records require a Social Security number, which obviously poses big security breach problems that have been documented. So
yeah,
if there's a way in this legislation, if there's a way to maybe try to address that, I don't want to interfere with the chairman or Ms. Bono Mac's bill, but if there's a way we can do something that doesn't necessarily cause other problems on the other side, where we can try to address a narrow part of that problem. I'm feeling it is. Thank you.
The chair really just want to again thank the witnesses. We've imposed on your time pretty significantly this afternoon, and you certainly are appreciative. We are appreciative of the fact that you've allowed us to do that, and you've been a great panel, and we want to make sure that if you be so kind, we want to keep the record open for at least 72 hours. And so there might be members of the committee, a subcommittee, who will in writing ask questions, and if you would respond in writing within 72 hours, the chair would certainly appreciate that. So thank you so very much again, and you've really done this subcommittee quite a great service. Thank you. The hearing is now stands adjourned.